All right, thank you for staying with Citizen TV's Monday Report. We're discussing the Kenya Information and Communication Amendment Bill 2025. A lot of questions are coming through. My guests are still with me, Honorable Marian Keitany, Member of Parliament Aldai, and Victor Ndede, the Technology and Human Rights Manager at Amnesty International Kenya. Let's bring up all the questions that you have at Trevor Mbidi at Citizen TV Kenya. Use the hashtag Monday Report. A lot of them coming through. Let's try and see if we can answer as many as we can. Felix Stephen says, my question to Marian: does the bill seek to enhance efficiency, especially in creating jobs specifically to content creators, or restrict internet users from cyber crimes or any other related activity? Let the honorable member specify.
I can answer.
Go ahead, yeah.
Okay, so this bill does not do any of those. What it only does is to ensure that the data, the money you use, you get value for your money. That is all. And therefore, if it is job creation, then it means if you are to use 50 shillings, you will actually properly use your 50 shillings to be able to give you the output that you require. Okay. That is what it is. But Victor said that there's a lot of vagueness. In fact, Victor had something to say before I go back to the feedback.
No, and I mean, the first part was around the vagueness, because, you know, and the reason why we'll insist on that is because in the eyes of many people, this bill will be viewed to be limiting the right to privacy. Because if already someone has access to your usage data, is converting that usage data into a readable format, and which has not been defined, of course, in the law, and that readable data is then sent over to the communications regulator, which is a state authority, then it creates the question of what exactly is being collected, what exactly is government being given, and these new data centers we are creating with the ISPs, that they have all the data that we access the internet. And I had Honorable Keitany talk about, you know, like what in big terms we call big surveillance or mass big tech surveillance, or what happens with the Googles, or basically surveillance capitalism, you know. And the bigger issue here is we've been trying to tell even the Kenyan government that these are things that we need to look at. It's not proper that, of course, once you access the internet, then you waive your right for people to track you across applications and platforms, then they target you with advertising. Because often this advertising has even targeted children. So it's not right, and it's not, because it's being done does not mean it's right. There are certain conversations that have actually been pushed to ensure that we stop this targeted advertising and mass collection of data that is used to target people with different things. But the more important question here is, how do we ensure that there's clarity in what exactly? Because the idea of what you're trying to do, I don't think anyone would have an issue with it from a consumer protection side. But in how the law is drafted, the vagueness allows for certain things to be applied, because later we'll get regulations post your amendments that now define what exactly is being collected, which has not been defined in the Act itself in terms of the bounds. And so what that would lead to is we will collect a lot of data, send this data over to government, and even if nothing happens, the chilling effect will have already been created. You have no idea who has your data, what they're doing with it. And so think about the work of journalists, whistleblowers, human rights defenders, who have to work pseudonymously or anonymously on the internet to do what they do.
Okay. Just to give the Kenyan public comfort in terms of what we are trying to do and what I'm trying to achieve, is that we've now reached the stage of publication. And immediately after publication, it goes into what we call the first reading. And then from the first reading, it will now be committed to a committee of parliament. In this case, the ICT committee, which is chaired by Honorable Kiaria. Honorable Kiaria's committee will have to do public participation. So that is a stage which views will be collected from Kenyans and everybody who has an interest in this particular amendment. Now that we all appreciate, and I like that you appreciate the object of what I'm trying to achieve, then if that is the object of what I'm trying to achieve and you like it and it is okay for the Kenyan public, then you can say, word it this way to achieve what it is that you wanted to achieve. And remember, at that stage of public participation, I don't have any control, totally. Because it now has left my hands. It is going to be at the committee of the parliamentary committee on ICT. Once the public participation is done, it is put together and it comes back to Parliament now to get into second reading, then goes into the stage of committee of the whole, where every member of parliament will go clause by clause, with amendments, of course, and with views from the public.
Okay.
Then finally it gets to the next stage. So for me, I would say, for as long as we understand the object of the bill, which is actually to protect the consumers, and that is the object of why I was introducing this amendment, then if the wording is of what I've put here could be wrong, then the public still has an opportunity, and the opportunity is now.
Okay.
And that is the reason for publication.
Yeah, I don't know if perhaps it would be a good point, because I mean, already and the reason why the bill has attracted the attention it has is because it is what others would consider fatally flawed. And the view then would be perhaps rewrite it before it proceeds, or withdraw it before it proceeds, and get it properly written.
Is that something you're open
because
to?
The danger is, Trevor, before she comes in, the danger is once it gets to the floor of the House, she has said she has no control. We don't know even how far much worse it can actually get, because the idea has already been planted that this bill could actually lead to mass surveillance. And so the best thing to do, because if the object is consumer protection, get it withdrawn, rewrite it in a consumer protection focused way, and have it come back to the floor of the House.
You feel the bill is fatally flawed as is? As is,
it's unconstitutional, because the framing is overly vague and broad. And if you look at if you look at the reading into it, it means that it's a bill that actually proposes to limit freedom of expression and the right to privacy. If a bill is to limit a fundamental right and freedom, there's a certain criteria laid down under Article 24, which then it will be weighed against, and the chances of it measuring up to the dictates of Article 24 are quite slim. And that's why I would advise the honourable member, if this bill can be withdrawn and redone.
Okay, and you've said that this is supposed to be for consumer protection.
Yes.
So have you done estimates of what financial impact this will have? How much will you save the public?
How much would I save
the consumer,
the consumer?
Who you say is your central focus?
So much, because if you look at how much we consume in terms of data and data bandwidth. Let me take a young kid, for example, a student, and a school-going student, college-going student. The amount of data they consume, they do like about 50 shillings a day, times 30 days. That is about 1,500 shillings. 1,500 shillings for data is too much. And that is data that if they had used maybe about 500 shillings, they would have still consumed the same amount of data within that same period. So they would have saved 1,000 shillings that they can use to do something else in that particular month. That is for one student. So assume so many other students. And you know, one thing government is doing right now is that they are providing internet or ICT hubs in every ward in Kenya. And us as members of parliament are actually building or giving the physical infrastructure for those particular facilities. That will come a long way in helping so that we don't need to have this particular bill coming through, because that will be free internet. So it doesn't have any billing at all. So this we are making reference to where now this particular youth who is not able to access the free internet now comes and wants to access through their gadgets and the privacy of their homes. So we want them to be able to then access this internet at the right cost that they have requested for this service. And then in terms of what he's saying, this, for me, this particular bill is not flawed, and he's saying it objects, it negatively impacts the Constitution of Kenya. I would like him to quote and say this is the part of the Constitution. But even if he doesn't quote here today, there is still an opportunity where the public, including himself, can be able now to say this particular clause in this bill objects this part of the Constitution. And I think as members of parliament, because our work is also to ensure that we have proper representation and we oversight in terms of legislation, we do not do a legislation that is going to object any part of the Constitution, because we know that the Constitution is supreme and it is the overarching law that we must all adhere to. So if any part of this bill objects any part of the Constitution, I think it would be nice for that to come up. One thing I would want to tell you is before even this pre-publication happened, views are normally sought, and actually views were sought from the Auditor General, from Kenya Law Reforms, because that is where we go to. And they actually gave positive comments to this particular amendment, because those particular entities look at, is this particular amendment going to interfere with any part of existing laws, one, and two, the Constitution. And I want to report here and say that when this was passed to them for scrutiny, they came back with a clean bill of health at that time.
Okay, but sneak in one quick line. On the cost of, and I mean, if the objects are to reduce the cost of internet, I think this would be a good moment, and even as you look at the finance bill in the House, to look at the cost of actually the taxes that are levied on digital services and goods, looking at cost of the taxes on internet, mobile data, call time, SMS, and all those things. If we were really intent on reducing the cost of these services to impact the young people, because often, and I can't have gotten the statistics now, but if you look at even the tax that some of these services attract, they actually even attract to an extent of excise tax on digital services. Yeah. And you know, the theory of excise tax is a sin tax. Tax is meant to dissuade people from certain things like alcohol, tobacco. Yeah. So if digital goods and services are attracting excise, well, then is the point to come and say that now we are fighting for your consumer rights because it's now the service provider who's pressing you hard, and yet the taxes are also pressing on the other side, which of course lead to high cost of usage.
Yeah, but Mheshimiwa, on top of that, you asked for the part of the Constitution that this violates, and I'm looking at the Kenya Constitution, specifically Article 31. Says guarantees the right to privacy, which includes protection against unwarranted surveillance. This right safeguards individuals from having their homes, persons, or properties searched without a lawful basis. This is where it gets even more explicit. And prohibits the unauthorized seizure of their possessions or the disclosure of personal information or data.
And that's why I've said this particular bill is not actually interfering with that data.
But you want us
with
to
the data as
the communication authority.
And
usage data at least once.
No, usage data.
Is data that gives away my traits.
Usage data is not. It's not about your traits and habits. It's about.
But you don't say it here, Mheshimiwa. Even in this particular one, you just say monitor customer usage. You don't say specifically.
Allow me to give you whatever that particular bill, the article you've read, already is being violated by people like Google.
But now you legalize it.
No, I'm saying, I'm saying, and this bill is not going to do what Google does. It is, you've taken it all wrong, and you've all taken it in a different context. I've told you the context in which this bill is all about. And therefore, when I say that convert data into readable format, I've given an example of electricity. How do you convert the light we are seeing right now into a format readable for a bill to be able to be given? How is it converted? How is it converted?
That is the interpretation.
Yeah,
that is not
saying that
the interpretation we read as we look at the bill.
No, that is the interpretation. I think you're just reading too much out of nothing.
Really. But you see how that would turn? Because we're saying here, you have not specified what, first of all, monitor customer usage is. You have not specified it. So it could be anything. And then there's more, that an internet service provider licensed will be sending this information at least once every year. It could be 3 times, 4 times, depending on what the government then decides. Say, Madam Ketan, today we want to see what you've been doing every month. You don't see how that can be abused?
For me, I don't, because that's what I'm saying. I think you are reading too much out of this.
We are just reading what the bills are.
My bill is so clear. Yeah. It's for you. I think you're just reading but you're being suspicious.
It's actually a Trojan horse, because you see, the thing is, you may have drafted it in that understanding, and that's what I'm saying. You may have that understanding that it's for consumer protection. But the reading of many people, and myself included, is that this is a Trojan horse that could open up a whole world of surveillance, because whatever data that you propose to be monitored, or the data usage is not defined. Whatever is being sent to the Communications Authority is not defined in law. And so if another person applies this law, or assuming even it gets to Parliament, into the committee stage and the readings, and it takes another form or shape, then and a shape for the worst, then you create a huge problem for us in privacy and freedom of expression.
And there's also another question.
And that is why
now to nip it in the bud and say your intentions in consumer protection are welcome. let's withdraw it and have a look at how we can get it properly done.
Before you
No, and that is why we are now going to the next stage, which is an open stage now for the public.
Okay.
And then you can say, how I have worded this is wrong, or is that is not very clear, it's vague, if you can reword it this way. Because Parliament always takes views, and we never throw away any views. Because, you know, you need to also appreciate what Parliament does. We never throw away any views of anybody, okay, especially at the public participation stage, because every view will be given in a report and the reasons why the committee decided to drop it or accept. So if they accepted, they give reasons. If they drop it, they give reasons as well. So in this case, if we feel that it is vague because you've understood the object of why I'm doing this bill, then you are welcome at that stage, which is the next stage we are going into, to say, change this word. Instead of saying monitor customer usage, you tell me monitor usage of, or whichever word you want to feel that, or you feel that you want to use, yeah, for as long as it gives me the result of what we are looking for. And the result is like the example I've given you of electricity, yeah, to convert this electricity into a readable format that can be billed. That is what it is all about.
There's also another question that, hi Trevor, at the tail end of the bill, the mover indicates that its passage will have financial implications to be provided in normal budgets. What does she expect the expenditure to be incurred?
It is not a money bill, and that is the reason why it did not go through the stages of a money bill. So there is no financial implication as has been mentioned there, because that has no financial implications. Okay. If it was a money bill, it would not have come through these stages. It goes through, there are stages it goes through, and it has to go through a stage where we see whether that financial impact will have an impact on the economy of the country. So this is not a money bill at all.
Okay. Yeah. Let's see what the questions are coming through. A lot of them are coming through. Let's bring that up and see on screen. And the next question from Joe says, the hallmark of this bill is on expired bundles as per the draft, yet there's a whole spectrum of non-expiry data bundles. How come there is no interest to have same on, for example, the digital satellite, television services, rentals, car hire, you name it? The question is, the hallmark of this bill is on expired bundles as per the draft, yet there is a whole spectrum of non-expiry of data bundles.
You see, for non-expired data bundles, you buy a bundle, let's say you're doing 2,000 shillings per month. So it does not limit you to how much in terms of data you use per day, per hour, per week. It is about, it's an open-ended that you're going to use this data per month. And
it doesn't have to be per month. It's just non-expired bundles. It's finished when it's used. You just buy it. It is on timing. Yes. It's on timing. Use it, and then but this particular one is not actually not on timing. It is both timing and quantity of how much data you're consuming. So the other one is open. You can use 100 GB, you can use 10 GB, you can use 12 GB. It is as open as how much you want to use. And we wish that, actually, I would have wished all data was like that. That would be good. Because then, when I buy, I would know I am going to buy for whatever quantity and whatever I would want to use for a certain period. But where you're being limited in terms of quantity and time is where my problem is. So because the focus is on that, on the expiry bundles only?
Yes, especially because the people who actually get affected on this is the people who are at the bottom of the pyramid. Because they actually buy based on what they think are sweet deals. And if you go to *544#, you'll find the sweet deals. You're told this is a very good deal. Pay 15 shillings for 1 hour for X amount of GB. Or pay 20 shillings for 24 hours for X amount of GB. And they know very well, these ISPs know very well, that by the time that period is over, you will not have used that amount of energy.
But do you see how blanket then this bill is? Because if I'm on the spectrum where it's non-expiry bundles, I'm still subjected to all this.
So imagine now,
even what I'm still using my data bundles for every once in a year. Do you understand why it's a bit too vague and captures everyone? For example, you've said your target is the people whose data expires and you feel they're being exploited. There are those in the spectrum who don't necessarily go through that, but they will still be subjected to all this regulation.
So those in the like, for example, those in the spectrum who on a billing system,
Yes,
there's a month that has no data, that has no non-expiry bundles.
So how does this
then they don't need to have their invoices would be a monthly invoice. It's an invoice of you are paying 2,000 shillings a month, and that's all. Nothing else that you provide. Yeah. So, but those ones that have a limit then of amount of data that you are consuming within the period, then you'd have to have a carry forward of the balance of the data that has remained for that person to carry forward to the next time that they require to buy a new bundle. Then they are told, in that buying of a new bundle, you have savings of X amount of GB that you need to, that as you pay, know that you have this savings. So you know you have this amount of GB that you can now continue using as you buy extra GB or extra bundles that you require to use.
But in that in itself, you can see how it segregates the entire community. So it's not everyone who this bill will be helping.
It is actually helping the bigger part, which is the people in the bottom of the pyramid. That is the people who are really affected by this particular data bundling, because those people are unable to buy the monthly figures. What the people who are buying monthlies are, like, for example, your company here, Trevor, will do the monthly, which is non-limiting, and all of you within the company can use unlimited. But when you look at this student, for example, that I've given, this example I've given, or this Mama Mboga who is told you need to go to the internet for you to apply for e-citizen, for you to apply for whatever it is you have to apply, they are not buying a non-expiry bundle. They are buying a few units to be able to access that service. And then tomorrow, they need the same service. Maybe they are applying for a birth certificate. Tomorrow, they are told, you've reached here, go back to the internet, and maybe the data has expired. We don't want that mama to lose that data that has expired. Okay. That is what I am looking for, and that is where the data protection part that I am actually focusing on is where I'm looking at.
Yeah, and I mean, all that you've said cannot be read in the bill, Honorable Keitany. All that you've said, because how we understand it, and in terms of how broad and vague it is, as we have constantly said, it doesn't give a picture that it is aimed at consumer protection. It looks like, initially when I read the objects, yes, and then now when you read the provisions, it then becomes a classic Trojan horse that once this bill becomes law, then all these other interpretations can be unlocked. And that's why we are saying this, in its current form, does not meet the object in how we have read it. Yeah,
in fact, and there's another person who's saying here that, ask Honorable Keitany, now that she uses the analogy of milk, just ask her what happens after she has bought bread in her house and it expired before she consumes it.
Did I buy the bread when it was expired in the shop, or it expired in the house? If it expired in the house, because this then I am the one who is at loss.
Exactly. So if I buy a data bundle that's supposed to expire now and I don't use it, isn't that my problem?
No, I bought the bread to consume, and there were instructions that said, consume this bread within X period of time. It actually tells me, consume within X period of time. If it goes beyond this period of time, it will expire. So I have that information already, and I've been told consume within this period of time. So in this particular example now, and relating to that, you're told consume this data within this period of time, and the balance of the data is my interest that carry forward to the next billing.
Okay, let me bring up some more feedback coming through here. Let's bring that up and see what you're saying. There's more feedback. Philemon, 2025. Says that has she considered how this bill may disproportionately affect low-income Kenyans who rely on shared or public internet services? Let's start from there. Would metering usage and invoicing individually exclude vulnerable groups who access the internet communally?
Like what kind of communal internet use access?
There are people who have Wi-Fi where you can now just go and access. If I give you my code, you can access it. And there are people who use communal Wi-Fi. You set a hotspot on your phone, other people use them.
So when, let's say, I'll have bought a bundle, or I'll have bought a non-expiry data, because if it's non-expiry data, it doesn't quite affect you. But if it is data that expires, then we are saying whoever bought that data, you may be using it communally, but whoever bought that data, then at the expiry of the time, the balance of that data should be carried forward to the next time when they buy new data or new bundles.
Okay.
Yes.
Let's bring up what you're seeing as well on the screen, as much feedback as we can. Concerned Liz from Nairobi says, Trevor, if their concern is if we utilize data purchases or we are getting fair deal from purchasers, why don't they end expiry of data bundles and expiry of airtime? Because that's where consumers are shortchanged.
What do you mean?
Yeah, why don't you just stop the expiry of data bundles, that you don't have to, it doesn't expire, so that if I buy 5 GB, then it just has to be the whole 5 GB.
So
there's no expiry on it.
If that would be the case, that would be good.
Why don't you address that here?
That would be good.
You said that your issue is the expired data bundles. Why don't you address it in such a way that there should be no such thing as expiring data? You finish all your data. If I buy 5 GB, it's the whole 5 GB.
Okay, one thing.
And there will be monitoring. Of course, your phone already monitors, tells you that today you've used 22 GB.
You said there'll be monitoring? The same monitoring we're talking about?
The phone is already there, yes.
So the same monitoring we're talking about.
Why do you need to authorize it
So
here?
we would then say that where the data is non-expiry, the only thing it would monitor is that your usage is still there until the day those bundles get finished.
Exactly.
Not expire, but until the day you consume the whole of it. And by the time you're consuming the whole of it, what then are you doing? You're still monitoring in terms of usage so that you know you still have this much, it is dropping down until it is zero. Because how else would you know that your data is coming down? It has to have a system in which that is used. And if the wording of using the word monitoring is wrong, then what do you want to use? What terminology would you want to use that shows that your data is now moving from, it was 15 GB, it is coming down until it is zero. And then the system tells you now it's zero, buy new bundles. It is, unless you have another name. For me, I would call it monitoring.
Okay.
Yeah.
Victor, did you get the argument from the concerned Liz, who says that if that is the concern, then just scrap off the expiry?
Yeah, I think, and that has been a conversation for a long time around expiry of all these digital goods, mobile data, bonga points, SMSs and all that. And that's why I'm saying if that is the intention, then I think the law should be pointed towards that direction, because in its current reading, it doesn't speak to the objects and reasons of this current bill before us. Okay. And it opens up a whole world of things that could lead to surveillance.
Okay. And if we look at ISPs right now, not only in Kenya, but in many parts of the world, they actually give this expiry of bundles as one of the packages that they sell. If they could say we are doing away with that package of expiry of bundles and you will use the bundle you buy until the end, the only thing you need to have is monitoring of that bundle until the end. But because they have that as a package, as one of the products they sell, then you cannot now start telling an ISP, stop selling this kind of service or stop selling this kind of package. We are now going to restrict you to this kind of package. So for those who still want to have expiries, then they should be told, the moment it expires, carry forward. Don't let the customer lose what has expired.
Okay.
Yeah.
Let's see what else you're saying here as we wind up on this conversation. Muliro Schofield says that the power bought in units is not readable to the extent that the provider, in this case, Kenya Power, does not know the specific equipment we utilize in our homes. For data, the conversion to readable format is not an equivalent example.
I think I need to explain what I mean by readable. You know, power is charged. It is not when you switch on a bulb at the socket, light comes. So that light, when it comes, how do you start charging it? That now I am consuming power into a form that Kenya Power has now called it units. How did it call it units? It's because it converted that lighting of that data to a format that they called units, and that is the reason why. And then that unit now runs down. As you're consuming, it is actually running down. If you bought 66 units or 60 units, for example, it starts running down until the day the units are zero. And the day the units are zero, your power, when you try and switch it on at the socket, it does not come on, it does not light, so you don't get the light. That is what I mean by readable. A readable format is where you're converting a service like now light to a format that can now be chargeable. And data is a similar example. Data as we speak now, is air. It is really nothing. It's you can't feel it, you can't see, but you can use it. So you are converting that, whatever is in those cables or coming through satellite or whatever method it is, to a format that can now be readable, to a format that can now be charged into what you are now calling bundles, or what you are calling units, or whatever it is, what name the ISP is calling, and a name that is agreeable across board. When you say bundles, it is, or you call it data bundles, they know it is bundles that are measured in terms of either speed or measured in terms of quantities that you are receiving.
I think, Trevor, based on that example, actually, that's where actually the problem now comes. Because you see, in the case of data, for you to establish what has consumed data, you'd have to establish what application, what browser, what downloads, so that you're able to actually bill. Because that's what, even if you look at your phone, it actually tells you, I used X for this much, and this is the data that X consumed. I used TikTok, this is the data it consumed. And so if you think about it in the data sense, what then this readable format would be, for my bill, it would show X 24 GB, Instagram X GB, all that will be there for people to read. And that's where the problem starts. Because it means then my invoice would read, because they just can't give me a blanket invoice and say I used 50 GB. They'll need to break it down for me. Because we have had cases where people say, I bought bundles now, all my bundles have been eaten. Yeah. And often when they go and check, perhaps at times they realize actually certain applications were either running in the background or in the foreground. And so if we were to provide that readable data, it would mean then that we provide our application history and our usage history for them to populate that invoice in the readable format. Yeah. Because otherwise it makes no sense. We can just get a 50 GB bill or invoice that has no details, if that was the case. But you see, in understanding the usage data alluded to in the bill and the readable format you are alluding to, then it means that all this data will be available for the communications authority, for the internet service provider, which of course at times for the internet service provider it may be there. But the question is, why is this coming to government on them needing to know how I got to my 50 GB a month bundle? Yeah. And so that's the difference with electricity. Because if I was to read what you're saying in the electricity context, then Kenya Power would be able to tell me that my microwave ate this much, fridge ate this much of power, and all that. So for the data space, I don't think it can go parallel and be compared with the electricity. This would expose people's browsing history, user habits, which are very critical data. May not be personal data, but they're behavioral data that can be used to now target them with advertisement. And even critics of government will actually get targeted, knowing which websites they visit, which platforms they use, and things like that. Yeah.
By the way, even for electricity, Kenya Power can be able to tell you the kind of gadgets you may have that is consuming more power in your house than not. Because there are times you can go there and ask them, why is my power going too much? And they'll tell you, we can see that you may be having this gadget that is consuming power. If I look at, for example, the mobile data usage on my phone, which is also similar to what you'd have on your phone, just as he said, it actually breaks down, other than giving me the global quantity of how much I've used for that period, it breaks down to, in terms of what service, it actually breaks down. So whatever information I'm asking is already there. It's already provided. Government. It's already provided. Government can even have access to this data because, remember, government has systems that snoop into this data. That is a fact. Yeah.
So you're admitting that government is snooping on everyone?
No, I'm not admitting that government is snooping. What I'm saying is that they have systems. Yeah. And that is the reason why, if there is crime that has been committed, you find that government is able to actually track and trace to the very bottom of what actually transpired.
Based on a certain legal process for them to access
and legal parameters.
Yes, once they have the legal process, they are able to access that data.
But now you see, this would be us having all this data in the absence of a legal process and legal oversight, all with the Communications Authority and the ISP, and this applies now to everyone, as opposed to someone who's either suspected of a crime where a legal process has been commenced against such a person. So that's why I'm saying this is actually just a blanket mass surveillance clause or clauses that have been introduced. And that's why we are saying in the current form and shape, they will not meet the test of constitutionality.
So let me ask you one thing, Mheshimiwa, before we finish. Under what circumstances will the Communication Authority receive personal data from people? Because what you've just said here is under specific instructions, either from the DCI or there's an active investigation, then they're allowed to check.
Yes.
When there's terrorism, they're allowed to check. This, you're saying that they will get this report every year at least once. And so under what circumstance? And that circumstance is not specified.
No. The report
it's for all Kenyans every time, once every year.
No, the report they will get is that the ISP is actually using this particular system for data, for analysis of how they are charging a customer. That is the information that I am referring to in this bill. That an ISP is not left just to say, I'm using a system that looks like this. So that system is a system that they are using actually fair to the consumer. Is it okay to the consumer?
So why
because every ISP will have their own system. I'll give you an example.
But not get readable data.
Or even allow for
I'll give you an example.
Rather than mass.
The ERPs that we use, not all of us use the same ERPs. Some use Oracle, some use Microsoft, some use whatever systems that they use. But in the objects of that ERP, if it comes to the financial system, does it have what you call a chart of accounts? That is basically, in summary, how this ISP, the service provider, the Communication Authority, who is the regulator, would be receiving this data to say that you, ISP, are using this system, but the end result, the data that I want from you is you are using a system that is billing customers. How are you billing these customers? How is the customer able to convert your data and be able to understand the metering or the metering that you're using to know that the data that I consumed or that the data that I bought was this quantity and now it is this quantity.
But
that is basically it.
And why don't you just regularize that so that the internet service providers declare how they are billing people without necessarily the government accessing all this data? Because you're using the analogy of Kenya Power and the electricity tokens.
Yes.
We know how much is billed per megawatts or kilowatts. Then why the Kenya Power doesn't send all the details about everyone every year? Because
we only have one Kenya Power. If we had more than one person selling power,
the pricing
like
of the
ISPs, then we would have... No, Kenya Power is only one.
Yes,
if we had more than one person selling power to consumers, then we would have needed to have a regulator to come in and say, now this power is going, you're going to use this system. Remember, Kenya Power is using a system that they just changed the other day and asked customers to change. So they would be saying, this is the system I use as Kenya Power. Somebody else would say, this is the system I use as my company. The other person would say, this is the system. Like right now, Kengen is sold for power by various independent producers. Those independent producers don't have one system. Everybody has their own different systems. But in all those systems that they have, it is agreed that in terms of units, this is how unit is measured, whatever system you will use, and this is how I receive the unit, and this is how I pay you.
Okay.
But so that is basically...
Just on that, yes. Do you need the data on all Kenyans' usage to verify that the ISPs are providing or are actually providing the service at the rate that was agreed? Would it, if this was to ever work, I mean, it would make more sense to perhaps just have audits of their systems rather than getting, I think there are probably now 30-something million mobile subscribers and probably slightly a similar number of internet users. Would you need 38 million reports on how they've been billed to be able to know whether ISPs are actually doing what they need to?
Remember, the bill actually says it's the billing system that you will be giving to the authority. It is not the data in the billing system, it's the billing system.
Not quite.
That is what it says. I mean, can I read what it says?
Let me read what it says.
Okay, you read.
What it actually
3D.
provides...
3D.
They're saying on 3D, an internet service provider licensed under this act shall submit to the authority at least once in every financial year information on the billing system.
Billing system, yes.
Including internet meter numbers issued to subscribers.
What is the information on the billing system? Because already in your 3C, you have defined what information is on the billing system, which is customer usage and the unique meter number. So this unique meter number and customer usage is read to be the information on the billing system, because what else would be information on the billing system?
So you see, the billing system that is being used is what kind of system are you using? Like the way I've given an example of, is it Oracle, is it Microsoft, what system are you using? And the meter numbers that you've given, you gave from number, the reference was ABC1001 all the way to ABC9999.
But
that is my thinking.
No.
Yes.
On the 3C, you clearly say an internet service provider shall operate a meter billing system which shall, A, assign to each customer unique identifiable meter number, B, monitor customer usage, C, convert customer usage into readable details, D, create invoices based on consumption, and E, allow for user verification of invoices. That billing system you're talking about captures everything.
That is the system.
It's the system that
it's not one.
So they're giving everything.
Because otherwise you'd have asked for the service provider details on the bill. But the information on the billing system, and even including internet meter numbers, the meter numbers are nothing without whoever is assigned to those meter numbers. And so essentially all this information is what is being submitted to communication.
Exactly. Usage data. That's in your bill. I'm reading your bill verbatim.
Yes.
On 3C, you clarify from A to E. So it's everything that is being given to the government.
Which has nothing to do with the data of the customer, because it's all about... No. It's just, what about the customer?
You just said the monitor customer usage.
That is part of the
data
system.
So to monitor customer usage, as I explained to you earlier, is actually for them to be able to know the bundles that you have bought, for example. But how else would we know the bundles?
But you say on C that you convert that customer usage into readable details.
Yes. Yeah. So this usage, to say that I have used 50 GB, that is what is monitoring customer usage. I used 50 GB. Just like the example I gave right now of your phone right now monitoring your usage. It is telling you how much GB you
But the information on that system, on customer usage, we have already said for the case of internet, 50 GB is a number. For you to get to 50 GB, the following applications were used. That is what would be included in that information. Which, of course, if that is transmitted, then it's an outright violation of privacy. Because why do I need the government to know that I spent 30 GB on TikTok, for example? Or 50 GB on a bad site, whatever the bad site would be.
And Mheshimiwa, do you see why readable details could mean including what exactly I posted on Instagram or what exactly I posted on Twitter?
I don't think it would mean to that level of what exactly you posted on Instagram.
You can read what I posted on Twitter, right?
However, even today, if the government wanted to know what you posted on Instagram, they'll still know.
Under circumstances that are qualified in the law.
Yes, under qualified.
Not a blanket one.
Yes, under qualified in the law.
If there's a reason why they specifically target me,
and if there is a reason, the government would now look for, go to court, seek orders, and actually use the data that they are able to access and access to know what you actually wrote.
One of the biggest concerns that the government has always had is dealing with pseudo accounts. Therefore, if I post something without necessarily using my name, it's difficult to tell. But with this bill, it will be very easy to tell that this person operating under X is actually Honorable Ketan. Are you concerned?
No. You know, even with pseudo accounts, they would still be able to know it is this particular gadget that was able to do the pseudo accounts. And that is why you find, like those people who hack bank systems, from wherever they hack from, they are traceable to the location and the gadget they used to track.
All right.
But what we're saying here is all this data availed to the state is it's a blanket surveillance. Anyone and everyone's data is already available, will be made available to the state. And we are not subject to
right now anyway.
No.
That doesn't make it right, Mheshimiwa. Anyway, you have to leave it there. Thank you so much for making time for us this evening. Honorable Marian Ketan, MP Eldai, and Victor Ndede, Technology and Human Rights Manager, Amnesty International Kenya. Thank you for having this conversation with us. We'll see what the public participation will yield on this bill, and we'll keep an eye on it, right? Thank you all for making time for Monday Report. On behalf of the entire team that made this possible, say good night and God bless.